Hello everyone, welcome back to my channel. I'm your friend Arman. So today in this video we're going to learn another topic of law of tort, and that is trespass ab initio. Okay, this is really uncommon topic, and I think nobody has discussed in their college days also, and there is nothing in the book regarding this topic. Okay, so this is a doctrine under the law of tort. One of my viewer requested me to make a video on this, so I thought of making it because this topic was really new for me, and I have never read about this before, and when I heard about this doctrine for the first time, I went to the book. Okay, I went to the book and I didn't find anything in the book, okay, regarding this topic. So thereafter I went to the internet, and in the internet also there is no sufficient like examples or anything explanation which could particularly discuss about the trespass ab initio to the goods topic. Okay, so whatever the things I could gather and whatever the whatever I could understand, so I'm going to discuss with you. Okay, so do watch this video till the end, and if you find this video helpful, do not forget to subscribe. Okay, so let's understand first of all trespass ab initio. Okay, and to goods, it is a added question on this topic. Okay, so trespass is what? Trespass is a tort, right? When like unlawfully entering to the someone's land, property or goods, that is unlawful interference, is trespass. Okay, so ab initio. So ab initio means what? Ab initio means from the very beginning. Okay, I think you know about this topic, the void ab initio. You have heard it in the contract law paper, right? So trespass ab initio. So trespass itself a tort. Okay, like while we were discussing about the trespass to the good, trespass to the land in my previous videos, like there is one thing that I have told you, that like if you take a one step to the land of the plaintiff, unlawfully, one step unlawfully, that is also a trespass. And if you go to the 1 mile inside the premises of the plaintiff unlawfully, that is also a trespass. So there is no question of beginning or ending, right? The moment you enter, that is a trespass, right? So what like trespass ab initio principle is talking about, we will understand now. Okay, so I have told you about the meaning of the trespass. I have also told you about the ab initio meaning, right? So now, so we'll compile these things and we'll understand now. Okay, so to the trespass to become void from the beginning, or say ab initio, that means the from the very beginning, trespass from the very beginning, to make it so there has to be, okay, there are certain essentials that we need to refer. Okay, essentials. Okay, so number one is thing that there is a prior authority. Okay, there is a prior authority on the part of the defendant. Okay, prior authority to the defendant. And number two thing is that the defendant violated the authority. Okay, suppose according to that authority he went there, but he did some like he violated the right, or say abused. Okay, there is an abuse word is used. So yeah, so he abused the right, or say authority. Number three, and that the abused must result in positive act, and the act should not be omission. The act should not be omission. Okay, so so these are the essentials. There are 4 essentials. The prior authority, there should be a prior authority, and he abused the right or authority, okay, and the abuse must result into the positive act, and the act should not be omission. Okay, so let's take the example. Okay, let's take the example. With that example, this essential will be clear to you. Okay, so the example is that, like, suppose this A is the owner. Okay, A is the owner of the house. So A is the owner of this house, and B is the tenant. Okay, tenant. Okay, tenant. Okay, so there is a contract agreement, I mean there is a tenancy agreement between A and B, okay. So so A here lets his house B for tenancy. You know, this is a tenancy agreement. Out of the tenancy agreement, he lets his house to B. Okay, with the condition that B will have to bear electricity bill. Okay, so B has to pay the electricity bill, and also B cannot make any changes in the house. He cannot, you know, he cannot cause damage to the property. Okay, he cannot cause damage to the property, and monthly B will pay 5,000 rupees as a rent. Okay, okay. So here in this case, like, he was entrusted that he was restricted from making any changes in the house physically or causing damage to the house, and he entrusted with the duty that he has to bear the electricity bill. Okay, so now, so after agreeing, okay, on the agreement, B signed that agreement and he took the possession of the house. Okay, B took the possession of the house. Okay, so he entered the house, and after that, what happened? He did not do certain changes. He did not do any wrong to the house. He did not cause damage to the property. Okay, for a couple of months. Okay, so the agreement was for 11 months. Okay, for a 2-3 months, he did not cause any damage to the property. Okay, but he did not pay the electricity bill. He did not pay the electricity bill. Because since he did not pay the electricity bill, so then he filed a suit against the B that regarding the trespass ab initio. Okay, there is a prior authority, right? So till here, he took the possession according to, as per the contract agreement is concerned. He took the possession. There is no wrong. There is no trespass. But he did not pay the electricity bill. That means he caused the breach of the contract. So he filed a suit for the trespass ab initio. But the court said that no, not paying the bill is what? Not paying the bill is an omission. Okay, it is not a commission, or it's not a positive act. Okay, so that's why the case was dismissed. Okay, so let's take the same example. You know, B took the possession and he is paying the bill. Okay, he is paying the bill, or say not paying the bill also, and he also, you know, caused the physical damage to the house. Okay, he, you know, did certain, like, there is a ceiling fan in the house, and he, you know, took away and sold that ceiling fan to the somebody else, and, you know, he did a lot of, you know, changes in the house. Okay, which is, you know, which causes damage to the property, and that is eventually a loss for the owner. Okay, so that is what the moment he started causing the damage to the property, that means he has committed the trespass ab initio. Okay, that means his act of breaking the house, or his act of, you know, causing the damage to the house, you know, his act, you know, entirely makes the entire thing, including the contract, a trespass ab initio. Okay, so that means there is a prior authority and he broke that authority. He was only given the possession to, you know, reside there. Okay, he was not authorized to do harm to the property according to his convenience. Okay, so that is why, so it is a trespass ab initio. So I hope it is clear to you now what is trespass ab initio. Okay, now we will see certain case laws. So there is a very famous case on this topic, that is Six, I think, Carpenters case. Yes, so Six Before discussing this about this case, I want to tell you one thing, that there is nothing in the book regarding the trespass to goods. Okay, trespass ab initio to goods. You will find a little bit about the trespass ab initio, about the principle. This is the principle doctrine, and you do not find any trespass ab initio and the goods. Okay, so that is why we have to rely on certain case laws which is under the, which comes under the trespass to property or trespass to land. Okay, so with the help of this case laws, we will try to understand trespass to good. And out of that, after analyzing all this, we have 3 case laws. So after analyzing 3 case laws, then we have to frame our we have to make the analysis, and we need to write about it. Okay, of our own language, in our own language we have to write it, because there is nothing in the book and there is no case laws particularly dealing with the trespass to the good. Okay, so that's why we need to do by our own. So watch this video carefully. Okay, so Six Carpenters case. Okay, so in this case what happened, there were 6 carpenters. There were 6 carpenters who went to the inn. Okay, who went to inn. Who went to the inn? Okay, inn means hotel. Okay, so 6 carpenters went into the inn, and what happened, like they ordered for bread and wine. Okay, they have ordered for bread and wine. They have ordered for bread and wine, and accordingly the seller, the hotelier, served them the bread and wine. Okay, and bread and wine, and they paid the bill, they paid the bill. Okay, that means the 6 carpenter paid the bill of that wine and the bread. Okay, and again after some time, again they ordered for the same same order. Okay, the bread, again they ordered the same bread and wine. Okay, and after that, when like they so the bread and wine were served to them. Okay, this is the second order. So bread and wine were served to them, and they took the they consumed all that thing. Okay, like bread and wine they consumed, and after that, like when at the time of payment, so at the time of the payment of the wine, at the bill, at the time of the payment of the bill, they started fighting. They started having quarrel. They started having quarrel with the owner regarding the prices of the goods served to them. That means the the bread and the wine served to them. Okay, so they started fighting regarding the prices. According to the 6 carpenters, the prices of the wine and bread is inconsistent. They said that this is the not a proper price of it, so they were reluctant. I mean, the 6 carpenters were reluctant to pay the amount to the hotel owner. Okay, so that's why they did not pay it. After fighting, they did not pay the amount. Okay, so thereafter hotelier, what he did. Okay, the hotelier, what he did, hotelier said, okay, hotelier said that I will see you in the court. I'll see you in the court. I'll file a suit against you regarding trespass ab initio. Okay, and accordingly he filed a suit in the court. Okay, accordingly he filed a suit in the court that these 6 carpenters has committed this trespass ab initio. Okay, but the court held that this is not the trespass ab initio. Okay, because what the court has said, that court said this is not the case of trespass ab initio. This is not the case of trespass ab initio. Okay, this is not the case of trespass ab initio, since there is no positive act on the part of the defendant. Okay, so the court held that this is not the case of trespass ab initio, since there is no positive act from on the part of the defendant, and not paying the bill, is an omission. So is an omission. Okay, so the court held that this is not the case of the trespass ab initio, and there is no positive act, and not paying the bill is an omission, not the positive act. So positive act is the essence of trespass ab initio. Okay, all right, so I hope you understand this topic. So remember this thing. Okay, remember these things, because we are going to draw the inferences while discussing about the trespass to good. Okay, and you have to write this also. While writing the answer about this question, you need to write the case laws that I am providing you. Okay, because there is no particular case regarding this topic, so we have to take the help from the cases which is available, we have, okay, available in our hand. So the next case law is Davis versus Passmore. Davis versus Passmore. Davis versus Passmore. Okay, so in this case, what happened? In this case, the police entered. Okay, the police entered to the premises of the P. Okay, to arrest P and others. Okay, so in this case, the Davis versus Passmore, the cops entered to the premises of the P to arrest P and others. Okay, so here the police, since the police has the authority to arrest the person, because someone has filed an FIR against the P, so that's why the P, that's why the cops entered to the premises of the P to arrest the P. Okay, so while entering the premises, okay, what happened? Like there was a door. Okay, so let's suppose this is a house and there is a door, and door were closed. Okay, and while the police were knocking down the door, what happened? They did not open the door. Okay, did not open the door because they have the idea that police has came to arrest them. So that's why they were hiding themselves inside the house. So that's why they were reluctant to open the house. Open the door. And what the police did? Police broke that door and entered the premises and arrest them. Okay, arrest them, and including, so while arresting them, what the police did? Police also seized. Okay, the police also seized certain documents. Okay, the police also seized certain documents which would be useful for their trial. Okay, which would be useful for their trial, and out of them, they have seized many documents. Okay, many documents, and out of them certain documents were returned to the victim. Okay, returned to the plaintiff. All right, so what happened? The case was challenged before the court. The arrest was challenged before the court, that the police, the contention of the claimant, or say the contention of the respondent, was that it is the trespass ab initio. Okay, since the police was only authorized to arrest them, but he caused the breaking of the door, and he also seized certain documents. Okay, but the court held that here. Okay, the court held that breaking of door is not trespass ab initio, and the police entrusted with the right. Okay, since he was entrusted with the right to arrest them, so that's why both the acts is not trespass ab initio. But the court says that the act, like seizing the documents, that is not under the purview, and police was not authorized to do that. Okay, so that's why to that extent the act was held to be trespass ab initio. Okay, so this is the case law regarding this. Okay, And another case law is there. So another case law name is Six versus F. Oh. Jones. So Chick Fascines versus Jones. I don't know how do you pronounce it. I don't know. Okay, I might be wrong. Chick Fascines versus Jones. So in this case, what happened? The police was, given the order by the court, search warrant. Okay, search warrant was issued against the certain person to the police. Okay, so police has the search warrant. The police has the search warrant. The police has a search warrant to find the stolen goods. Okay, so since there was a doubt that this is the house. Okay, this is the house of P and this is the house of G. Okay, so let's suppose the police was entrusted with the right to search for the stolen good in the house of the P. Okay, in the house of the P, and police entered the house. Okay, police entered the house and he did not find the goods that he is looking for. Okay, police did not find the good that he is looking for. So what he did, he he assumed that he finds certain another goods. Okay, and he finds certain goods which is not though he thought that this could be the good. Okay, this could be the good. Suppose there is various goods. Okay, let's suppose X, Y, Z, P, Q, R, S, T. Okay, there is various goods inside his house. So though he entered into the house, and he with the erroneous belief. Okay, he with the erroneous belief, reasonably that with the erroneous belief he believed that this could be the good. Okay, this could be the good. This could be the good which is complained of in the search warrant. Okay, so he went to the house and he took away the goods, erroneously believing that this is the good that the warrant is talking about. So he took away the good from here. Okay, and though the good is not the exact good that is looking for under the search warrant. Okay, so that's why it was challenged, the the seizure of the good, the seizure of the goods, seizure of the goods. So he went to the house and seized the certain goods with the erroneous believing it to be the good which he was authorized to take. So he went to that and he did that. And what happened, the seizure of the good was challenged before the court. Okay, then the court said that this is not the case of trespass ab initio, because it is the police is under the erroneous belief, and later on the goods were returned to them. Okay, returned to the defendant. Sorry, a plaintiff. The goods were returned to the plaintiff. So this is the case. Okay, so these three cases are really relevant in the case of the trespass ab initio. Okay, now we will see. Now with the help of these three case laws, it is now clear that what is trespass ab initio. Okay, so now talking about the trespass ab initio to goods, then we need to analyze, and we need to use our brain, and we should write about it out of our own language. Okay, so what we can do, okay, we can say when it comes to trespass ab initio to goods. So when it comes to the trespass ab initio to goods, then we can say, okay, so trespass ab initio, the principle is what? There is a prior authority, but he violated that authority. So that is the trespass ab initio, is not it? So what is the trespass of good? First of all, we need to understand what is trespass to good. So if you have watched my previous video where I have discussed with you what is trespass to goods. So trespass to goods is the what? Like throwing a stone to someone's car, or chasing the animals of the plaintiff to run away from the owner, and all that thing, all that thing are trespass to goods, right? So I'll not discuss about that now. So I'm just going to the straight. but while writing the answer you need to mention a little bit about the trespass, what is trespass to good also. Okay, so without mentioning that, your answer will not be completed. So now listen. So trespass to goods. So trespass ab initio to goods. So here let's understand. Okay, so there is a prior authority. Okay, so there has to be prior authority in case of the trespass to good also. Prior authority, and that authority should be violated by the trespasser. Okay, so so prior authority, who will give the prior authority? The owner will give the prior authority to the defendant, right? So let's take the example. With that example it will be clear to you. Okay, what is the trespass ab initio to goods? Okay, so there is a car. Okay, so this is the car and this is the car. This is my car. Let's suppose this is my car, and my friend, my friend wanted the car for hire for 1 month. Okay, he hired that car from me for 1 month. Okay, so I have given that car with the rent of like 25,000 per month. Okay, 25,000 for a month. Okay, so my friend X, asked my car for 1 month with the 25,000 rupees. That he said, I will pay 25,000 rupees, give me your car for 1 month. Okay, he said that. Okay, so I agreed with his proposal. I agreed and I have given that car to him. Okay, so I have given that car to him, and what he did, so out of here, okay, so till here there is an authority. I have given the car to him with my willingness, with the consideration of rupees 25,000. I have given my car out of my willingness to X. Okay, but so till here it is there is no trespass. Okay, but after that, he took the car from me. Okay, and he has been driving that car, and what he did, he started, suppose there is a music system in the car. Okay, there is a music system in the car, and what he did, he sold that music system from my car. He removed that music system from my car and sold to somebody else. Okay, accordingly he has done certain things inside my car, like he has suppose he started, he did a certain modification inside my car. Okay, certain modifications according to his will. Okay, suppose he put the sticker on my car, and he also started writing a name on my car, his name and all that. So that is what, so with that, so those kind of acts will be termed as trespass ab initio to goods. Okay, clear? That means, like, see, initially there is a prior permission. I have given that car willfully, but gradually, he makes certain changes in the car. Okay, he sold that music system inside the car to somebody else. So that means what? That he has caused the damage to my goods. He has caused the goods. Okay, all right, but so this is the positive act. Okay, this is the positive act because he has done certain thing. Okay, certain thing, but like there is a condition that I have asked him, like there is a EMI to pay in the bank, that is rupees 5,000 rupees you need to pay to the bank. Okay, and 25,000 you need to pay to me. Okay, so in total there is a 30,000 rupees. 5,000 you need to pay to the bank, and 25,000 you need to me. Okay, so here in this case, if X paid the 25,000 rupees to him but did not pay the 5,000 rupees to the bank. Okay, he did not pay the 5,000 rupees to the bank, but there is nothing wrong in the car. Okay, he did not do anything wrong with the car. That means he has committed the omission. So omission, so you cannot say omission is not a trespass ab initio to the goods. You cannot say it now. Okay, so that's why in order to commit the trespass ab initio, there has to be positive act, and that act is to result to the damage to the property or certain changes or disfigurement to the property. That means to the goods. Okay, so since he did it, X did it, so X did changes, like he sold the music system, he put in the sticker, made certain modifications in my car. So that is what? That is the positive act, and he has done that, and out of that, I have lost the true value of the car, and so that is the loss in the car, right? So that is we call the trespass ab initio to goods. Okay, so this is all about the trespass ab initio to the goods. Okay, I hope you understand this topic. Okay, if you have still any doubt and query, then you can ask me in the comment section, or you can follow me on Instagram. My Instagram handle down there in the description box. So I hope you find this video helpful, and if you find this video helpful, do hit the like button and share this video whoever in the need of this video. So thank you so much for watching this video. Have a great day. Bye bye.